The 2024 election was a lot. And now that we're past it, you might be avoiding political news altogether. Or you might want to understand the other side of the aisle, but without poisoning your algorithm or treading into online territory that feels like an alien planet. You need Left, Right, and Center. It's your weekly political news check-in with representatives from both parties, so you can hear from the other guys in a way that helps you actually make sense of it. I'm David Green. Join me on Left, Right, and Center from KCRW. New episodes drop every Friday wherever you listen to podcasts.
When parents list school shootings among their greatest fears, they're, of course, terrified of their own child being targeted. But surely some tiny subset of parents has an even more unsettling fear, one they might hesitate to even talk about, the fear that their child could be the one pulling the trigger. From KERA in Dallas, this is Think. I'm Krys Boyd. We want to believe parents with even the slightest sense that their child could be violent would seek intense and immediate help. Therapy, medication, whatever. We want to believe those parents would fully cooperate with school authorities who had concerns. And of course, we would expect those parents to block their child's access to deadly weapons. But that is not what happened in Michigan in 2021, when a 15-year-old student shot 11 people at his high school, including 4 classmates who died from their injuries. Ethan Crumbley was charged as an adult, pleaded guilty, and eventually sentenced to life in prison. But the county prosecutor overseeing the case became convinced the teenager's parents deserved a share of the blame. And as we'll hear, she was willing to risk her safety and her reputation to hold them accountable. John Woodrow Cox is an Enterprise reporter who embedded with prosecutors in Pontiac, Michigan as they pursued those charges against an entire family. His long-form article for The Washington Post is titled Guilty: Inside the High-Risk Historic Prosecution of a School Shooter's Parents. John, welcome to Think.
Thanks for having me.
So you really spent extensive time on this story. What made you decide to devote the better part of 2 years of your life to this?
You know, I've been writing about the impact of gun violence on children in America for many years now. Since 2017, I wrote a book about this subject. And, you know, one element that I always thought was undercovered was just access to firearms, children's access to firearms. And, you know, we created a database of school shootings going all the way back to Columbine. And in analyzing all those events, one thing we could say definitively is that if children did not have access to guns, more than half of those school shootings would never have happened. They would not have happened. And that's still true today. If children didn't have access to guns, then, you know, more than half of school shootings would just end. And you know, that's sort of disregarding the huge rate of suicides among children who live in homes with unsecured firearms. That also ignores the children who find those guns and accidentally shoot themselves or someone else. So I always really viewed it as kind of the low-hanging fruit of this issue, and one that, you know, we knew from analyzing historical cases that very rarely do prosecutors hold gun owners, period, whether they're the parents or someone else, the adult gun owners, very rarely are they held responsible. So this struck me as potentially a watershed case that I had never seen a prosecutor take this step in charging parents with homicide as a result of a school shooting. So right away, it just seemed like something that would be different and significant on this issue. And so right away, I had hoped to do something deeper.
So it doesn't seem like an easy thing to convince prosecutors to open up their offices and their private meetings to you. The only condition, though, that they set appears to have been that you weren't allowed to write about any of this until after the conclusion of all of the criminal cases?
That's right. I mean, I think Karen McDonald especially, she's an avid reader. I think she's a student of history, and I think she understood the significance of the case, whether they won or lost. Certainly, though, they were taking a risk in letting me in, because I could have seen what would have been, I think, for many of them, the low moment of their careers had they lost. So, you know, I think that the fact that I'd written a book about it, that sort of helped my case in getting inside. I think that all helped. But certainly, yeah, there was great risk to them. I mean, like any story that journalists do, there are elements that are inevitably off the record, small things that that are held off the record, which is true on any story. And occasionally they would ask me to for witness interviews or witness prep, things like that. They would occasionally ask me to step out of the room, but it was really rare. I mean, I was in the room for virtually anything that I wanted to be in the room for.
So in my introduction, I gave just the broadest outlines of the shooting. What context do we need to understand why Karen McDonald, who you mentioned, who was the elected prosecutor in Oakland County, Michigan, became convinced that Ethan Crumbley's parents deserved to be held accountable for what their son did wrong?
It began with them, Jennifer and James Crumbley, buying their son a firearm, a 9mm that Mrs. Crumbley characterized as his, quote, Xmas present, his Xmas gift. This was obviously in late November, so she framed it on social media as this was sort of his early Christmas present. They went to the gun range and tested it out. They themselves described it as his firearm, not as their firearm that they were letting him use, but as his firearm. There was evidence very quickly when they reviewed the parents' phones. This is after the shooting, that showed that the day before the shooting that the teenager had been caught in class looking up ammunition on his phone, and they had called the school, or the school rather had called his mother and left a voicemail. And so she texted her son, and kind of made a joke of it. She said, did you at least show them a pic of your new gun? And he said, no, I didn't show them the pic. And then at the end of this exchange, she said, and I'll just read the quote, LOL, I'm not mad. You have to learn not to get caught. So that was another element that was pretty shocking to the prosecution. The most compelling thing, though, was that the morning of the shooting, he had on this math worksheet basically drawn what he was going to do. He drew a picture of the 9mm that his parents had bought him. He drew a picture of a person who was shot dead. He wrote things like, the world is dead. Yeah, blood everywhere, quote, blood everywhere. The thoughts won't stop. Help me. All in a worksheet. So this is found. A teacher sees this. The counselor gets involved. And the counselor immediately calls the parents. So both Jennifer and James come to the office. They're there, if I recall correctly, for 11 minutes. It's a very brief meeting. He asks if they can take him home, and they decline to do that. They say that they have work demands. Jennifer returns to an office, a real estate company where she was worked in marketing, where by the account of other parents there, they often brought their kids with them to work. James Crumbley was a DoorDash driver, and he started making deliveries. By the account of the witnesses there, neither of them gave their son a hug. Neither of them asked about the gun. They didn't ask if he had it with him, if it was in his backpack. They left, and a few hours later, he opened fire, killing 4 students and wounding 7 other people in the school.
How did Jennifer and James Crumbley, the parents, try to disappear themselves in the days after the shooting? So
there was obviously an intense. This was the time. I mean, this sort of says something, I think, about gun violence and mass shootings in this country. But at the time, a shooting that many people now sort of don't remember, it was the biggest news story in the country for a moment. And obviously, there was a lot of interest in the parents very early on. They ultimately left that area. They went to a hotel, and then there's a lot sort of in dispute about whether or not they were fleeing. But ultimately, these charges were issued. They did not turn themselves in. There was a massive manhunt in the state of Michigan, and they were found in a warehouse, this sort of commercial building in Detroit, where police had been searching for quite a long time, bashing doors in, and they were found sleeping, laying down. That's a little bit in dispute whether or not they were awake or not when the police finally broke this door in and arrested them.
But this was long before they had been formally charged themselves, right? And it's not a regular thing for parents to be charged in connection with their children's crimes. In fact, parents of a school shooter, as I understand it, had never before been charged following a homicide committed by their kids at a school. Did they ever say why they went on the run?
So they had never been charged with homicide. There have been parents who have been charged with lesser crimes in the last 25 years, but this was certainly the most serious charges that parents had ever been charged with. That element, though, when they were I think accused of fleeing, that did occur after these charges were formally issued. They had left their own home, though, certainly before they were charged. Part of that was, I think, the media scrutiny certainly was intense. Their home was being searched. I mean, it wasn't considered a crime scene, but it was certainly a scene of evidence. So the police were going through every single element, every single of anything in that home, for digital evidence, for other firearms. And so they had been asked at a point to leave because they had to search the house. The police had taken their phones away. So I think they did what I think most people would do in these situations, and what we've seen other parents do, where they sort of go stay in a hotel. And then there was this sort of additional step that certainly the defense would not say that they were fleeing. The prosecution certainly did say they were fleeing. And ultimately, the judge in the case thought that was credible. I mean, one really unusual thing about this case, these people would have been released on a lower bond, and they would not have spent the last, 2.5 years in jail if not for the element of flight. The judge certainly thought there was compelling evidence that they were fleeing, hiding, unlike most parents in this situation, without a criminal history. They would have been released. They would have been living out in the world, but instead they spent all this time waiting for trial behind bars.
John, let's shift back to the prosecutor here, Karen McDonald. In pursuing these unorthodox, unprecedented charges against the parents of the shooter, did she have a broader goal besides bringing in these two individuals she thought might be partially culpable? Was she looking to send a message of some kind?
She was always insistent that that this was a unique case, that with a unique set of facts, that she wouldn't have charged them without those set of facts. But certainly in her initial press conference in charging this, she did talk about sort of the responsibility of broader gun ownership. And that, people needed to take care of their guns and prevent them from falling into the hands of their children. I think, though, that repeatedly she went back to this idea that, even if, however she felt about this issue politically, that if not for these really what she considered egregious set of facts, an egregious level of negligence, that she would not have pursued it. I think certainly there was hope among all the people who worked on this that there would be, it would be a thing that people would pay attention to and potentially would save lives, beyond Oxford.
From the outset, John, the prosecutor, Karen McDonald, faced resistance within her own office in bringing charges against the parents, James and Jennifer Crumbley. What were the concerns of the people who worked for Karen McDonald about these charges?
I mean, these were really credible attorneys, people who had prosecuted a great many cases. And some of it was highly technical. It was issues of the law, whether or not they could actually prove these charges before a jury. And a lot of it was around this idea of whether the parents' actions fit the definition of gross negligence that Michigan law required to convict someone of involuntary manslaughter. So part of that process in those early days was just pouring through these Michigan statutes. Her team was just pouring through these records to figure out whether or not it did, in fact, fit the definition. Ultimately, she decided that it absolutely did. And there was a point, I think, when she made it really clear that, there was this sort of dramatic meeting where she gathers all of her senior attorneys. She's reviewed all the evidence. She's looked at the law, and they're still very much undecided. There's still resistance. And she walks into this meeting and says, I want to hear your opinions, be honest with me, but, know this, we're charging the parents. She made that decision because she felt in her bones that it was the right thing to do and that the law supported it. So at that point, everybody got on board and really started digging into it and on how they would write these charges, because it was, involuntary manslaughter is a lot different than something like first-degree murder. And a lot of it is highly technical. And that really was a lot of their resistance in the early going was, does the letter of the law actually fit this case?
So, as you mentioned, involuntary manslaughter often requires prosecutors to prove gross negligence. What does that term mean legally?
So that is complicated. That is complicated, and could take the rest of the segment, honestly, to explain.
Can you give us some general understanding of it?
Yeah. So that is a really technical thing that actually the prosecutor spent a huge amount of time trying to determine exactly how they would explain this to jury in a way that was both factual but also understandable, because it is highly technical. The way that the prosecutor, the assistant prosecutor Mark Keast, explained it is that involuntary manslaughter, unlike something like murder, it is by definition unintentional, and it's rooted in this idea of negligence. And it's committed when someone's basically their acts or their failure to act means that they've failed to perform a legal duty. That is what happened here. That's what they alleged, is that the parents of Ethan Crumbley, that he had a legal duty to the other students at that school. And specifically in this case, they were alleging of these 4 kids who were killed, that they had a legal duty to act in a way to protect them. And it had to reach this point of obviously of gross negligence. And what they alleged was that specific meeting, these parents buy their son a gun. They know that he has access to that gun because it's not locked up. They go to school. They see this math worksheet that is clearly somebody who's thinking about committing a violent act, or at least that act is in his mind, and they walk away. And they don't do anything to intervene. So the prosecution determined that met that sort of legal duty, that they had failed in their duty to protect these other students at that school.
It's my understanding that prosecutors often lean heavily, at least, on the recommendations made by local law enforcement. But the sheriff's office in Oakland County didn't initially suggest charging the parents. Is that right?
That is right. Yeah. So Lieutenant Tim Willis, he was the lead investigator on this case. And early on, after they had come to the prosecutor's office and presented the evidence against the shooter, Karen McDonald immediately sort of pulls aside this lieutenant from the sheriff's office and says, what do you think about charging the parents? And he said, absolutely not. I mean, that was his recollection. That was her recollection. He was totally resistant to it. And a part of it, everybody involved, including the attorneys in her office, part of the resistance was rooted in this idea that it just hadn't been done before, that there was not precedent. Certainly attorneys want to base their actions on precedent. Our legal system is built on precedent. But that is also really true for law enforcement oftentimes as well, Lieutenant Willis was not familiar with this having been done before. Also, he was exhausted, having spent hours working the most horrific crime scene of his career, and he was very much focused on the shooter at that point. So part of it was his mind just sort of hadn't come around to this idea. Certainly over time, he became fully on board, somebody who absolutely believed they should have been charged, and he was their key witness, one of their key witnesses in the case.
People in Karen McDonald's family describe her, people who've known her whole life, describe her as having been a strong-willed kid who didn't care all that much about grades. She was a risk taker who didn't necessarily feel bound by all the rules. It doesn't sound like the classic profile of somebody who grows up to be a prosecutor, but I'm curious about the evidence that you saw of those early attributes in the energy she brought to these particular cases.
Yeah, I think she had a really strong sense of justice, like early on, and fairness. Even like some of her earliest memories were, sitting at the kitchen table at her home, and she was one of three girls. And one of her earliest memories, she must have been, 4 or 5 years old, is sitting at the table, and her mother was yelling, and just sort of thinking like, this isn't right, that this is wrong. I didn't do anything to deserve this. And it's one of sort of these formative moments. And she felt kind of that sense all the time. I mean, an anecdote that wasn't in the story, but that I thought illustrates that idea is she and her sister, she has a twin. And once they were teens, and her sister had just started driving, and someone struck her sister's car. And Karen was in the passenger seat. And as her sister remembered it, Karen immediately springs out of the car to go confront the driver of this other car who was at fault, basically to tell him that he had done this thing that he shouldn't have done, and that he was in the wrong, and that how could you do this to my sister? So those sort of protective instincts kicked in.
Maybe that does sound like exactly the sort of person who would grow up to become a prosecutor.
I think there were elements there. I do think there were elements there. I mean, she was always sort of disinterested, though, in grades, and she was not somebody who was ever striving to be the valedictorian. I think part of it was she just sort of hadn't found her place in the world, and also I think part of that could be attributed to the sort of the chaos at home. But she did always, I think, have a really clear sense of right and wrong, and also that paired with an extreme work ethic, that once she sort of found things that she was interested in, she would outwork anybody, and two, a really deep well of empathy. She is an extraordinarily empathetic person, and I've spent enough time to know that is real. A great many, 90% of that, didn't make the story, just because you can only write stories to be so long. But brings a lot of empathy to a job that we probably don't typically think of as being that kind of a central quality that a prosecutor would have. But that certainly shapes the way that she thinks about the job.
It was significantly risky for her to take this on. I mean, she'd only been on the job after having been elected. It had been less than a year, right, since she took office. Mm-hmm. And then she was getting threats. And these they didn't feel like idle threats.
No, I mean, the very first day, she was getting inundated with threats on her phone, email, social media, very specific threats about killing her, raping her. I mean, really violent, vile threats, and they never ended. And they were so intense that very quickly they realized, and they seemed credible enough, that very quickly they realized they needed to have security for her. I think that was over the course of this trial. That was certainly in the back of everybody's minds. But it fundamentally changed her life, her ability to just be a normal person and go out and do normal things, to take walks with her dog, to go to the grocery store. Those were all things she quit doing. I mean, she has a detail that really stuck with me, was she has a glass front door, and she really regretted that after this, and she quit walking in front of it because, not only was it easy to see through, it would be easy for somebody to shoot through.
So these cases would turn in part on the Crumbley parents' failure to properly secure this weapon so it couldn't be used by their son to harm anyone. But Michigan had no law requiring gun owners to secure their weapons. Is that correct?
That is correct. Yeah, there was no safe storage law in Michigan at the time. And certainly that would have made the argument, I think the legal argument, cleaner and easier and simpler had that existed. It does now. Since the shooting occurred, the state of Michigan did pass a safe storage law. But no, it did not at the time. And the prosecutor decided that she did not need that to prove that this met the criteria of involuntary manslaughter.
So what McDonald and her team had to demonstrate was that securing the gun would have been a simple common sense thing that pretty much any responsible person would do and know to do?
So they argued it in a number of different ways. So they said that, as they put it, there were innumerable, quote, tragically small ways that this could have been stopped. one of those ways, not the way, but one of those ways was if they had secured this firearm. And, the gun came with a cable lock, which is a very simple device that you can thread either through the barrel of a gun or through the magazine well that makes it inoperable. And they had that and had never used it, the evidence showed. So that was one of the arguments. Another argument that certainly they made is they could have just taken their son home. They could have said, is the gun in the backpack? There were other things that, other interventions that they argued to the jury that could have occurred. And they argued that this was one of them. Certainly in the minds of jurors, that was a key element.
I think Ethan Crumbley pleaded guilty and expressed remorse. Did James or Jennifer Crumbley express any remorse at any point?
I think they certainly expressed sorrow for the parents. James Crumbley in jail calls described himself as a martyr more than once and felt like he was the victim. Jennifer Crumbley took the stand and she was asked by her attorney if she considered herself a victim. She thought for several seconds about how to answer that. Ultimately said that she didn't want to call herself a victim because she didn't want to sort of offend the families, but that she agreed with her attorney that she had, quote, lost everything. And she also said that she wouldn't have done anything differently. She said on the stand, looking back, that she would not have done anything differently.
Did James Crumbley also make threats, maybe not directly to Karen McDonald, but against her?
He did repeatedly in jail calls that he knew were being recorded, because he would comment often, I know these are being recorded, really profane threats, intense threats. He promised retribution. He called her terrible names. He said that she was effed when I get out. She would be sucking on a hot rock down in hell soon. A very direct threat. And they were all recorded, and he knew it at the time, too.
A huge part of any criminal case decided at trial is selecting the jury panel to hear and decide on the evidence. How did McDonald's team approach that process?
That was a really fascinating thing to witness. It took them days and days. And what they did is they got these names, both sides, as in any case. They get the names of the people in the pool in advance. And they did kind of what journalists would do. They looked on social media, they Googled their names, just to try to find any clues that would suggest whether they might be a good juror or one that would not be a good fit, that they don't think would be sympathetic to their case. And then they created a spreadsheet, they took notes, they added questions if these people actually made it into the jury box. So that they did a huge amount of preparation in advance of both trials.
What was McDonald's able to learn about whether juries came in with any pre-existing bias against her as the person pursuing these unprecedented charges, presumably in a community where lots of people might own firearms?
Mm-hmm. Yeah, there was a lot of worry and paranoia about that. Ultimately, she wanted her colleague Marquise to lead jury selection, but a jury consultant had told her, look, if people show up with this bias against you, you need to take it on straight away. You need to, flesh it out and undo it. And there were certainly people in the larger pool whose opinions worried them. None of those people that I recall made it into the jury pool, people who said, at least, that volunteered, that they had strong opinions one way or the other about the prosecutor. But it was a thing certainly that they were concerned about and had prepared for.
John, are there particular challenges faced by women prosecutors in how they present themselves before a jury that are perhaps less of a concern for men in the same job that might account for why, for example, Karen McDonald wanted her colleague Marquise to do jury selection?
Yeah, there's a huge number of challenges that are unique to being a female prosecutor rather than a male prosecutor. I think, a lot of that probably could be credited to sort of television as kind of in the same way we almost think about coaches or people in these sort of positions of authority, that qualities that are seen as beneficial in men are often seen as somehow a negative in a woman. So, she was preparing for this. There was so much she had to think about. The way she dressed was she was very deliberate. She wanted to make these strangers feel comfortable, to reveal their prejudices, right? So she wanted to be committed and not controlling. She had to be smart, but also not condescending. She had to figure out if they owned guns without making them feel judged about whether they owned guns. And she needed to be likable. And, I think some of those are things that certainly a male prosecutor would think about. They all want to be likable. That is for sure. I mean, you talk to jury consultants or prosecutors, they know that it is important to win a case, which is a little bit scary if we think about sort of our system, that the likability or dislikability of a prosecutor or a defense attorney can actually maybe influence the way that jurors think. But these were all things that she was hyper aware of and was very careful in the way that she responded to any juror. And if they gave her pushback or if they said anything that was derogatory about her or the case or any of it, and that did happen. I mean, there were people who spoke up and sort of slammed the case, but she had to be very careful about the way she approached it because she knew there would be a different level of scrutiny entirely because of her gender.
Setting aside her gender, I mean, sometimes a person decides that a particular cause is something that they will pursue at whatever risk to their career and their sort of personal well-being. It's another thing entirely to sort of get the rest of the team on board. I'm curious about what fellow prosecutors who work under her say Karen McDonald is like as a boss and a mentor and a colleague.
I mean, she has real devotion around her. I mean, it's a big team of people, and they are truly devoted. And, I spent enough time to be able to recognize whether that was real or not. And I also saw these people at their most exhausted and vulnerable and their guards gone. And there was, without question, there was devotion. I mean, I think they believed in her belief. Also, some of it goes back to that element of empathy. She was always really aware of how everybody around her was doing. She was checking on them. Not to say that she didn't have a hard edge, because she does. And also has very exacting standards. I think under someone else who maybe wasn't willing to work as hard or who couldn't maybe muster that sort of devotion, it might not have gone that way. But she very much leads by consensus, even though this really didn't start with consensus. She does like to build consensus. She likes to go around the room, regardless of people's stature. She wants to know their opinions. I mean, I saw her many times turn to the legal aides, people who are not attorneys and want them to express their opinion.
People may recall that these trials made national headlines in part because the charges brought against the parents were so unusual. The fact that they made national headlines meant they were the national subject of debate for a time. How much did McDonald pay attention to the criticism lobbed, not maybe specifically at her, but at the idea of ever holding parents accountable for an action that their child took?
She was very aware of that, especially as it led up to trial and when the trial started. It wasn't so much that she was taking that personally, but she thought that criticism or those differing opinions might give them insight into what the jurors were thinking, or worse, that the jurors would even be maybe reading some of that material. There was one particular case, a moment the night before her closing argument, when the New York Times published an op-ed. It was an opinion piece that really questioned the entire premise of the prosecution. It was titled, if I remember right, what is this mother really guilty of? And it was, it was pretty critical of the case that they were prosecuting. And she read the whole thing and actually she asked Mark Keast, who was going to cross-examine Jennifer Crumbley the next morning. He said, you need to soften your approach. We sort of can't martyr this woman because maybe these jurors are looking at her in a sympathetic light as well. So she made use of that. I mean, she really thought that it was important to pay attention to those things just to gauge what it was that other people were thinking, because they were so inside this. They obviously viewed it in a very, very specific way.
What do you know, John, about how jury deliberations played out in Jennifer Crumbley's trial? The two parents were tried separately, we'll remind people.
They were, right. So Jennifer Crumbley was tried first. That really made it the more historic case, because if she was convicted, she was going to be the first parent of a school shooter ever convicted of homicide. And so I ended up talking to 3 of the jurors on that case. And it was enthralling. I mean, I was totally fascinated to hear about their process. They took an early vote. So, the case ends and they take kind of a poll of where everyone stands, and 8 were guilty, 2 were not guilty and 2 were undecided. And the 2 not guilty had very different reasons. One of them was a woman who saw elements maybe of herself in Jennifer Crumbley. Her husband owned guns. She worried that what if something like that happened to her or someone like her? Could she also be convicted of a crime like this? And the other jurors sort of talked her through maybe why she was different than Jennifer Crumbley. The person, though, who really was the holdout, there was one man who, he had no kids, no guns. He was a college-educated professional. And he viewed the evidence in a completely different light than anyone else did. And one way was that he was very dismissive of sort of the mental health aspects that the prosecution had argued. He was dismissive of the relevance of the meeting at the school. He did not think that was relevant to the case. All he really cared about was the gun and who was responsible for locking up the gun, how he got access to the gun. And, at a point on the first day of deliberations, it got so heated, he was, cursing by his own account. He was cursing at the other jurors, and at one point blurted out, "I guess we're just going to have a hung jury." And the prosecution was feeling that anxiety because he had asked a couple of questions of the judge, which juries do all the time. They send questions to the judge for clarification. And one of the questions that he asked is whether or not they could infer anything from the fact that the prosecution did not call the shooter. And that signaled to the prosecution that they were in trouble, that this jury was maybe going the wrong direction or would hang or would maybe even be an acquittal. And there was a local reporter who was sitting back there and overheard this person say that, well, that sounds like it could be an acquittal. So it was very intense, and it went into the second day.
So Jennifer Crumbley was found guilty. About a month later, James Crumbley's trial commenced. Did the strategy differ significantly in that case than in the case against James Crumbley's wife?
It did differ. It did. They focused more narrowly on the gun, the storage of the gun. It was a simpler case. His case was simpler than hers. I mean, there were these really complicating elements in hers. One was that one of their witnesses was this firefighter with whom she had been having an ongoing affair. They called him as a witness because he alleged that she had shared some things with him that were incriminating. Sort of those dramatic elements did not play a role in James's case. The focus really in his case was very much centered on the gun. He was the one who bought the gun. He was primarily responsible for the storage of the weapon, even though it was his wife who was last seen with it in public. She took her son to a gun range on the Saturday before the shooting, which was on a Tuesday. So that was very much the focus, is that he bought his son the gun, he didn't secure it, and there was this really sort of dramatic moment in the closing arguments when Karen McDonald puts on these gloves and illustrates for the jury live how to apply a cable lock to a gun, and she did it in something like 10 seconds to sort of make this argument how simple this would have been to avoid.
Do we know both the Crumbley parents were ultimately sentenced to serve 10 to 15 years in prison, which is like the maximum? Do we know what sort of contact they maintain with their son, who is serving a life sentence without the possibility of parole?
So if I remember correctly, because this did come up at their sentencing, I don't think they're allowed to have any contact with him or each other for the time being. And I don't know if that would change. If their appeals were lost and exhausted, that they could have some sort of contact, but I don't believe they're allowed to have continued contact with him.
I mean, Karen McDonald and her co-counsel, Mark Keast, were candid with you about the toll these cases took on their lives. Do they believe that their choices might somehow prevent future violence?
Yeah, I think they would like to believe that, certainly, if only because of the coverage of this. I mean, the day of Jennifer Crumbley's conviction, it led all three nightly news broadcasts. This was the lead story, and that was a day when there had been major political news. So, if that alone, it's impossible to quantify these things. But there was some local reporting that there had been an increase in cable lock sales, that suddenly people were showing up to local gun shops and buying more cable locks. So, I think having reported on this issue for a long time and responses I've seen to other events, I can say with confidence that certainly there were people who saw these proceedings and decided to go out and purchase something that, whether it was a safe or a cable lock, something like that, to better secure their weapon, or they already had it and they just started using it. There was a level of awareness, absolutely, I think, that was brought to this issue. And having reported on this specific issue for so long, my experience is that gun owners want to behave responsibly with their firearms, and that they certainly don't want their children to take those guns and commit a heinous act. There was never any allegation that James and Jennifer Crumbley wanted their son to do something like this. And I think that's true, especially in cases of suicide and accidental shootings. There's enormous regret. And I think a lot of it is based in ignorance, is that not everyone knows the risks that they're running by having an unsecured weapon in their home. And this just raised a level of awareness that didn't previously exist. So I think everyone involved would sacrifice what they did again. And it's not just because I think of this prosecution and what that meant to the victims. I think too, it also extends to how it might benefit society writ large.
I completely understand that people who would like to prevent all gun violence would like to see guns better secured and people taking every possible step to ensure that they don't fall into the hands of people who might do the wrong thing. What's so hard about these preventive measures, though, of course, is that you'll never prove a negative, right? We may never hear about potential shootings of any kind that didn't happen because, say, parents took preventive action, even if they saved lives by that action.
Yeah, that's absolutely true. It is, and it's a frustrating part of, I think, being involved on this issue. I've written about it, like I said, since 2017. Maybe the most satisfying moment of my career. So I wrote a book a few years ago, and after it published in 2021, the Post ran an excerpt of it, and that excerpt was about a gun unsecured. It was actually in a safe, but his 11-year-old son, knew where the key to the safe was. And was not a kid who really showed any interest in guns, certainly never showed any interest in violence or depression or anything like that. He had lots of friends, incredible student, just a great kid in every way. And one night, they had Taco Bell, and then he goes to his room. He goes to his parents' room. They're out in the living room watching TV, and they hear this pop. And his father rushes in and finds that his son has shot himself. And it just destroyed them. And, we ran that story as an excerpt. It was one chapter in my book. And so the Post ran it. And I got emails afterwards from people showing me the gun safes that they had bought as a result of that excerpt. And, that's sort of a rare moment in something like that. And again, in those cases, I don't know that it actually prevented anything. We can never know if one of those fathers' kids would have ever picked up one of their guns. But it was certainly gratifying to know that at least a few people were going to secure their firearms in a way that they hadn't before. And I think ultimately, even if there was not a larger effect, the prosecutors would have said it was worth it, because they were very, very, very narrowly focused on the injustice that they thought had occurred here, and that the role that these parents played in the deaths of those 4 kids at Oxford High School.
John Woodrow Cox is an Enterprise reporter. His long-form article for the Washington Post is titled Guilty: Inside the High-Risk Historic Prosecution of a School Shooter's Parents. John, thank you for making time to talk today.
Thanks so much for the thoughtful questions. I really enjoyed this conversation.
You can find us on Facebook and Instagram. The podcast is available wherever you get your podcast. You just need to search for KERA Think, or listen at our website, think.kera.org. Again, I'm Krys Boyd. Thanks for listening. Have a great day.